Good morning, everyone. Welcome. A big welcome to everyone who is joining me this morning. Can you all hear me all right? I am wearing a new lapel mic, so I want to make sure that you can hear me. Bad echo. Hold on, give me a second. How's this? Is this better? Okay. All right. Well, let's try this again. So, good morning, everybody. Welcome, a big welcome. Thank you for joining me this morning. My name is Molly Blazek, and I'm an attorney here in Omaha, Nebraska. My specialization is in guardianship, conservatorship, and special needs estate planning. Still echo bad echo and feedback. Okay, let me try something else. Hold on just a second. Okay, I'm going to try this for a third time. Hopefully, third time is a try. Can everybody hear me? Hmm. Anything better now? Well, I think there are some people who are saying that it's all good and some people who are saying that it's not good. So if you can't hear, check your own internet speed, check your own speakers, because I'm hearing from a lot of participants that the sound is good to them. So I'm going to get rocking and rolling. Okay. Good morning. Thank you for joining me today. My name is Molly Blazek. I am an attorney here in Omaha, Nebraska, and I specialize in guardianships, conservatorships, and special needs estate planning. I'm so excited to be here with you this morning. Believe it or not, this is actually my third presentation for the week. On Tuesday last week, we were with the city of Omaha doing some retirement planning seminars for firefighters that were on the verge of retirement. So Lionel, Eric, and I were there Tuesday morning. Lionel and Eric are both associates at Blazek Law Group. On Wednesday, I was at Elder Justice training, and in the morning, I was speaking about guardianships. And now today, I'm here with you fine folks talking about special needs estate planning. And yes, this is being recorded. I'm actually going to upload it Monday morning as Guardian Connect Radio's podcast episode for the week. And I'm going to put the replay video on our YouTube channel. So if you can't hear me, don't worry, you'll get access to the recording. I'll send you the slides. I'm sorry, I don't know what the technical difficulties are this morning, but it's not happening for everyone. So I'm just going to keep going this morning. So, okay. For some of you, this is going to be a refresher, and it's always good to have a refresher. There are going to be things that we talk about this morning that you probably already know. And for some of you, this might include things that you maybe have never heard before. And I want to keep the conversation dynamic. I want to make sure that you get what you came for this morning. Now, remember, you get what you pay for. So we'll see if you leave satisfied. But I do want to keep this dynamic. So I've got the Q&A open. I've got the chat open. If you have questions as we're going along, please let me know and I will stop and I will answer them. But starting now, we're going to kick it off, and I'm going to get to the topic that you really want to talk about, which is special needs estate planning. So, at the heart of special needs estate planning, what we're really doing is protecting those that we love who might be on needs-based government benefits. And that's what this morning's presentation is really all about. So, what is special needs estate planning? Basically, it's planning that uses particular and specialized strategies to protect those that are receiving those government benefits. Now, there's all kinds of examples of government benefits that are needs-based, but usually in our world, we're talking about two main ones. These are on your slides today. Medicaid is number one, SSI is number two. Medicaid is needs-based health coverage, and if you're participating in a Medicaid waiver program, it might be even expanded from healthcare coverage. There are opportunities for people who have TBI and developmental disabilities, as well as a whole other section of the population, which is aging, which would allow for them to stay in their home or receive Medicaid and assisted living facility. It's not just nursing home care that we're talking about here. It's Medicaid in all of its components. And then SSI, which is supplemental security income. This is a different kind of benefit than maybe people are familiar with. Usually when you think of Social Security, you think of retirement. Sometimes you might think of disability insurance. This is if you've worked enough quarters and paid in that you can make a claim for disability insurance if you become disabled. SSI is slightly different because it is a special benefit for people who have never worked and cannot be gainfully employed. So we see a lot of special needs children who are aging into adulthood at age 18 applying for SSI if they're not going to be able to meaningfully work. Now, there are special programs that allow individuals to work and receive SSI. Sometimes there's an adjustment to the monthly benefit that you get if you're working at the same time that you're receiving. But for the purposes of our presentation today, we're just going to be talking about the two of these benefits in the sense that in order to maintain eligibility for them, you have to stay below certain income and resource limits. That's really what we mean when we say needs-based government benefits. Sometimes people, well, okay, let me be honest, lawyers. Sometimes lawyers use terminology that's really, common for them. But when people say it, like when they hear it from an attorney, they might not know what the attorney is talking about. I find this to be true when we talk about trust funding a lot. We'll talk to our clients like, oh, you need to fund your trust. And the client's like, well, great. What does that mean? I feel the same way when we talk about needs-based government benefits because we kind of let that roll off our tongue without really explaining what that is. And what it is that you have to meet certain income and resource requirements in order to qualify. So it's not like you can be gainfully employed, have an income, have resources, that make you a millionaire and still get these benefits. These benefits require you to be under a certain income limit and under a certain resource limit. I've got the two resource limits for Medicaid and SSI on the screen. Medicaid is a little more generous than SSI. Medicaid is $4,000. This means at any given time, a Medicaid beneficiary has got to be under $4,000 in resources. So if they have a bank account, let's say, that bank account can never go over $4,000. But it doesn't just stop there because all of your resources get counted for this test. So if you have a bank account, if you have personal property, if you have things that total in excess $4,000, you are going to be disqualified from Medicaid. It's the same thing for SSI, except with a lower cap. To remain eligible for SSI, your total assets have to be under $2,000 at any given time. So you can see how low these numbers are and how receiving an inheritance from someone might really compromise their ability to stay on Medicaid and SSI. Okay, let me pause here because I see the chat and I see the Q&A going off. Okay, let me see. Okay, what about SSDI? SSDI does not have a resource limit because it is based on your working quarters. Now, if you're on SSDI and Medicaid, that's different. There's going to be a $4,000 resource limit for you to remain eligible for Medicaid. But SSDI, disability insurance, DI, does not have a resource limit. SSI is different. Okay, what are the beneficiary requirements to open an SNT? My now adult child has a diagnosis of ASD from an early age and is receiving Medicaid. She has been denied SSI, SSDI to lack of evidence that her diagnosis prevents her from engaging in substantial gainful activity. Can I create an SNT or not? You can absolutely create an SNT. Absolutely. You, as the trust maker, can create a special needs trust for your special needs beneficiary, even if they are not on government benefits. I see this a lot in people who just have general concerns about maybe their special needs child being able to manage an inheritance. So they might park the inheritance in a special needs trust for a trustee to manage, but they can also remain gainfully employed. They don't have to, like, I guess what I'm trying to say is there's no requirement that you are on government benefits in order to have a special needs trust. Sometimes you can be on one benefit and not the other. Sometimes you might be on a completely different benefit and not the ones that I'm talking about here. AABD would potentially be an example of that. That's a state program that provides supplemental income to people. It's not much, but that's another benefit that's needs based that could be talked about. So we're not just limited to these automatic qualifications of being on Medicaid and SSI. You can absolutely create a special needs trust, even if your child is not currently receiving benefits. All the special needs trust is really saying is if this person is on needs-based government benefits, the trustee is not to give them any money. But that doesn't mean that they can't have a trust and still benefit from the protective strategies. Sometimes you don't even need a special needs trust to do that. It would be, I think, smart to have it set up so that it's self-adjusting. So our trusts, for example, that we write in this office are self-adjusting in the sense that we don't necessarily put people into a particular defined category. Our trusts say, if at any time any of my beneficiaries are disabled or on needs-based government benefits, or for any reason that the trustee deems to not make a distribution for them, we're going to hold their share in trust. One of the important things about special needs trust planning is that it's very simple. If you have a special needs child that has a diagnosis, you know they're going to be on these government benefits. But there's a whole other aspect of special needs trust planning, which is for things in the future that haven't happened yet. For example, you could have an adult child that has no special need, but they get into a car accident at age 28. And now they're disabled. Now they're getting SSDI, like the attendee was asking about. There's no resource limit for SSDI, but they need to qualify for Medicaid. That trust can be self-adjusting so that it kicks in those protective strategies for even future events that you haven't anticipated yet. So it's good to work with someone who's going to be able to make a self-adjusting trust for you, because this is not only limited to your children, it could also be your grandchildren too. Maybe some of your grandchildren that haven't been born yet. So you want to create a plan that is self-adjusting, that's going to cover the known things that are in your life, but also be able to kick in if there are unanticipated, unknown things happening in the future. Short answer, yes, you can absolutely create an SNT. Okay. So what are the protective strategies in a special needs trust? Here, I've got it on screen for you. This is plain English. There's no legalese here. Number one, you leave their inheritance with someone else. So you direct the inheritance to another person on the beneficiary's behalf. So let's just take my family, for example. In my parents' trust, it probably says, if any of my children ever become in a situation where the trustee can't make a distribution to them, they become disabled, or now they have a special need and they need to, be eligible for needs-based government benefits, we are not going to give them their direct share of our estate. Instead, we're going to hold it back and we're going to pick one of our other children to manage it for them. So you're leaving it with someone else. You're saying, I'm putting you person who's trustee in charge of another person's share of our estate. And I'm going to give you a couple of illustrations and a few more slides, but I just wanted to give this to you away from the way that lawyers talk, because at a basic level, what you're doing, number one, is you're leaving the inheritance with someone else you trust. So not your special needs child, but perhaps another child or another relative or a trusted friend. Or sometimes you might even be looking at a bank, a financial institution, or trust companies can serve as trustees, but you're not leaving it with the person who is compromised by receiving it. You're leaving it with someone who is going to be able to manage it for them. And then within the body of the trust, you're giving clear instructions about how your trustee should use the funds to care for your loved one. So you're explaining things that are important to you. You are saying, here's how I want you to use their inheritance. I don't want you to use it in a way that's going to compromise their eligibility for government benefits, either currently because they're receiving them or in the future if they might need to apply at some point. Now, remember, it's not a straight line. Sometimes people are working and not receiving SSI, but then they lose their jobs, and it might take them a while to find a new job, and you'd reapply for SSI and you'd start that benefit again. So there are times that it might be fluctuating the role of the trustee, and you don't want to compromise the beneficiary's eligibility for SSI if they're in that position where they're kind of turning a switch on and turning a switch off. I have an exact example of this for a woman that I'm guardian for. She was injured at birth, and as part of that, someone filed a medical negligence claim on her behalf, and she received a huge structured settlement. Now, the amount of money that she's dealing with is managed by a bank because it's so large. A financial institution was chosen to manage it, and all of this happened long before I ever became this woman's guardian. But what happens through the structured settlement for her is that she will be given a lump sum, and then it'll be a number of years until she receives another lump sum. So sometimes she will run out of that staggered amount sooner than the next installment is coming in. And when that happens, we reapply for Medicaid for her and we reapply for SSI for her. And that's what pays for her to be able to maintain her standard of living in the interim. She's on DD waivers, so she's in a medically needed group home with a local DD agency. But when she's not private paying through her structured settlement, she's got to go back on government benefits. So I have a real life example of that happening based on a structured settlement that she's receiving. And third, this is the biggest idea. This is the biggest way that you've got to make sure that this works, is that the person has no direct access ever to the money that you're leaving them. So they can't make a withdrawal. This is your special needs child or your special needs loved one. They can't demand money from the trustee, and they have no ability to say what happens to the money at the end of their lifetime. So if you've got a situation where one child is the trustee and your other child is the special needs beneficiary, the special needs child can never go to the trustee and say, I want $100. If they have the ability to do that and the trustee is required to give them money, it fails the test for a special needs trust. The only way that it works is if the special needs beneficiary can never demand money and the trustee is never in a position to have to follow those instructions. So the actual language in the trust is, my trustee will use their discretion in order to allocate this inheritance to supplement the needs of this particular beneficiary. So whatever the government is not providing through their benefits, if there's a transportation issue and you need to provide transportation, if there's maybe uncovered medical expenses, my trustee has discretion to pay for those, but it's entirely in the trustee's prerogative to make the distribution, which is why you have to pick someone that you implicitly trust to carry out these instructions, because you're relying on them to be able to recognize and identify the need of the special needs beneficiary. I think family members are the most ideal people to do this because you're going to be able to read between the lines and you're going to know the wants and needs and desires of your family member, whether it's your brother or sister or your cousin. You know, you're going to know this person much, much better than a stranger would, like me or a bank would. And you're going to pay more particularized attention to their care. That's just the way that it works. So we always really, really stress people to look at family members to do this, but it doesn't always work that way. Sometimes you might have a family member, but they're not trustworthy enough to do it, or it's impractical for them to do so. They might be, you know, a professor in China and they're not in the States and your special needs child is here. But knowing the beneficiary is extremely critical because you're relying on your trustee to be able to carry out these instructions, which is why part of this planning also includes a set of instructions from the trust makers, from you. I assume the people who are watching are trust makers. Maybe you're trustees. That would be cool too. But it's really, really important that as part of your planning, you have instructions on how you want these decisions carried out. And I'm not talking about the boilerplate language like no withdrawals, no demanding distributions. I'm not talking about that. I'm talking about the real essence of what you want for your child. You know, for me, travel would be huge. I've traveled internationally a lot. I would want my child to be able to have that same opportunity. That's one thing that would be really important to me. Avoiding living in a group home would be another thing that's really important to me. It's those things that you know about your child and you want for your child that also need to be included in this plan. And we take a lot of pride in making sure that we partner with clients to be able to provide these robust instructions to their trustees, but not every special needs attorney does that. So just know that that's something that you want to also include. It's not going to be part of the trust language. It's going to be a separate document, but you're sharing what your, you know, really your hopes and dreams are for your special needs loved one. Okay, but the individual can have $2,000 in resources. I'm not sure what that means. For if you're an SSI recipient, that's your cap. So you can have $2,000. So, you know, your benefit amount is going to be around $900. That's what it is this year. It's in the high 900s. So you're basically able to keep what you're getting per month, pay your bills, and then the new month starts over. But yes, you're allowed to have $2,000. So there's some ability to have a little bit of uh, padding there, but not 2000 in cash. Well, cash is a resource. So however you add up the total resources of an individual, personal property, cash on hand, the total of that can only be $2,000. Cash is much more difficult to deal with because you can't trace it. Family member could be stressful in general, especially a sibling. Do you mean for the family member? No. Okay. It's $2,000 at any given time. So your balance is fluctuating. If you're receiving an SSI benefit, they're assuming that you have some expenses. If you don't have expenses, you're not going to get the full amount that's available to you. That's actually something that could probably be its own workshop, which is something that they refer to as in-kind support. So like if, for example, you are an SSI recipient, you're living with your parent and your parent is not charging you room and board, that's an in-kind support allocation. They're going to reduce the amount that's available to you monthly. So if you're getting things for free, it's going to reduce what you're eligible for from SSI in the month. So assuming that you've got a housing expense, assuming you've got a food expense, you're going to allocate something to room and board or rent or a food budget, and then you're going to be able to get the normal, like full amount of SSI, but you can't ever have more than $2,000. So if you're spending your SSI, which is what is sort of assumed by the benefit, you probably won't run into a resource limit. But here we're talking about two different things, and this is actually a really important distinction that we've stumbled upon because when we're talking about the $2,000 resource limit for the individual, we're talking about their money. When we're talking about special needs estate planning in this particular workshop, we're talking about someone else's money. So like mom and dad's money, grandma and grandpa's money, aunts and uncles' money. Those are two different things when it comes to the world of special needs estate planning. The special needs person money is different and your money is different. Your money is referred to as third party money. The individual special needs child money is called first party money. Now, for a special needs child who's got a $2,000 resource limit, if they get to that ceiling, there are things that you can do outside of what we're talking about today to be able to make sure that they maintain eligibility for government benefits. So here's the most practical example I can give you. You have a special needs child, you're their guardian, they get SSI. They either live with you or they live with a shared living provider, and there's a room and board expense. It's the same amount under any scenario. So let's say they get, let's just make it clean. It's more than this, but let's just say it's $900 a month, okay? Room and board is 600. That leaves them $300 to spend on entertainment or, extracurricular activities or anything else that they need, clothes that they might need. Maybe winter time is coming up, they need a new coat. That $300 is there and available for them to use. Their housing is covered, their food is covered, they're fine there. But let's say they don't always spend $300 per month. Soon, you're going to get up to that $2,000 resource limit, and there's something that they're going to have to do in order to make sure that they continue to maintain their eligibility. So they're either forced to spend the money when they don't need to, or they could do something like open an enable account. So you could have an enable account as part of your special needs child plan. So for their first party money, if there's ever any spillover, you're not needlessly spending, you can put it into an enable account. Now, if you're already at a place where you can never have more than $2,000 at a time, the worst thing you can do as a parent or a grandparent or an aunt and uncle or someone who's leaving money to that special needs beneficiary is say, here you go, here's 100,000, put it into your guardianship checking account, because that's immediately going to disqualify them from government benefits. One of the things that's also really important to know about special needs estate planning for third party money, so your money, again, mom and dad, grandma, grandpa, aunt and uncle, your money, is that when you do the planning properly, there's no risk of your money going back to the state of Nebraska at the end of the special need beneficiary's lifetime. That's not always the case in other scenarios. So you can, for example, say, I want, and I've got an example of this coming up. So we'll just kind of talk about it here and then we can pick it back up in a future slide. But I'm going to give $100,000 to my special needs child, William. And if William doesn't use all that money, then I want it to go to my grandchildren that my other kids have. With a first party trust, so for William's money, you would not have that opportunity. And enable gets really confusing, although there were some recent law changes that are making it more so that there's not Medicaid recapture on enable accounts either. Still not a great plan to put your money in an enable account. Better plan is a third party special needs trust, but enable is changing to become more attractive. So just know that if you're aware of enable changes, some of that is leaving us. Some of the things that made it unattractive are leaving us. Yes, Stephanie, exactly right. Enable account can help. Thank you so much for saying that. Okay, let's keep going. All right, so here was the example. This is at least the beginning of the example that I was talking about. How do you actually make special needs trust planning work? I don't like the fees associated with the enable account. That's feedback that we get. We get that from certain parents. For us, for the value of what we're getting, we think that it makes a lot of sense, because otherwise, we might be spending several $100s every couple of months on things that we don't really need. So the 14 or 15 bucks that it is every quarter is not a big deal to us compared to what we might have to be wasting in other scenarios. But that's not feedback I've never heard before. Some people dislike that. Another complaint that I hear is when you're using cards like I don't know if you're familiar with TrueLink or Greenlight, but it's these cards that allow financial management for a special needs individual to receive their petty cash. Sometimes there's fees associated with that. Sometimes people don't like having to pay those fees. Again, for us, the protective strategies that are involved with those cards to make the $4 to $5 monthly charge to us really worth it. Like TrueLink, for example, if I give Charlie, money on his TrueLink card, I can identify where I want him to spend it, times I want him to spend it. So, like, I might turn it off at 9 p.m. every night. Or I might say, we're not going to spend money at any restaurants if there's overspending at a restaurant, or I'm not going to allow ATM withdrawals. So, just there's a ton of protective strategies involved with some of those accounts, which makes the $4 to $5 to us seem really reasonable. So, it's really a cost benefit analysis, because if you're forced to waste $500 a month, well, then $5 a month in a fee is not that big of a deal. But if you've got needs, you're going to be spending that money every single month, no matter what, and you don't need an enable account. That's certainly something that's happening to people in Nebraska. So it's just about making wise choices given the situation. Every situation is unique. Everyone has goals that are independent and unique to whatever their needs are. And that's just an important thing to remember during any conversation about a guardianship, a conservatorship, or special needs planning. We're talking about real, breathing individuals that have needs, wants, and desires that are personal to them. So no two situations are alike. So let's look at mom and dad and their three kids. So mom and dad have three children: Sally Sue, Johnny, and William. William is special needs. I was talking about William earlier. Okay, so mom and dad, they want to leave $1,000 to William in their estate plan. So their document actually says $1,000 to William in a special needs trust. Then it goes on to say Sally, Sue, and Johnny are co-trustees for their brother William and will manage the $100,000 left in the special needs trust for him. At the most simple form, this is what your estate planning would look like if you wanted to leave money to William in a special needs trust. Now, Sally, Sue, and Johnny don't have to be co-trustees. You could say, I want Sally to be the trustee. And if Sally ever can't do that, then I want Johnny to be the trustee. Or you might say, you know what? I don't know that Johnny really should be the trustee ever. I think I'm going to make Sally Sue the trustee, and then I'm going to appoint a bank as the successor trustee. There are so many ways to do it based on your family dynamic and what's important to you, and really how much money we're talking about. So there are, lots of different ways to customize your trust planning. It's really about identifying what your goals are. And it's important to partner with someone who's going to make you think about your goals instead of just being secretarial to you. We were talking about this on Tuesday when we were presenting to the City of Omaha firefighters that were retiring. Often we find in estate planning in general, lawyers are very secretarial with their clients. So their client will come in and their client will say, this is what I want my estate plan. The attorney or their support staff will type it up. Client will come back and sign, and that's really it. That's not what you want. That's not what you want. You want a bigger conversation like, well, I know William is special needs. What do you think about him? What is his life going to look like? Who is he going to live with? Do you want to, make sure that he doesn't go to a group home? Do you want him to live at home? Do you want him to live with a shared living provider? How much money do you really think William's going to be able to use in his lifetime? Maybe it's not an equal third of this estate. Perhaps we want to only give William $100,000 because it's unlikely that he's going to spend a third of the estate like Sally and Johnny would. Maybe we want to give Sally and Johnny more money because we won't be tying up that extra money for an entire generation. It's about prompting you to think through what you want. And that's what we want to see in estate planning. That's certainly how we work with our clients. It's identifying your important goals and then prompting you to think through how all of this is going to work. That's another thing that I think a lot of attorneys miss in counseling their clients in estate planning is you could even have a conversation where you talk about goals. You could create an entire estate plan and have it not be secretarial. But if you don't actually think about how it's going to work after your clients are gone, you're still missing a huge step and a huge part of the conversation. And that's actually one of the things that I find most heartbreaking in practice for me is that people will do an estate plan and they think that it will work for their child, and then they're gone and things change and it's not working out the way that they planned. And so they died believing that their child was protected, and then it turns out that it doesn't go any way that they want. I'll give you an example of this. Right now, I'm the guardian for a gentleman who is special needs, and his grandparents adopted him. And as part of that adoption, they provided for him in their estate plan. And these people were rather wealthy. So they had some banks serve as trustee of the special needs trust for my ward. Now we're talking, like these trusts had more than $1 million in them. And so they picked these banks that they had relationships with. They had relationships with these bankers. I'm sure felt really confident and assured that these banks, these financial institutions would, adequately provide for my ward. And now that we have gotten to a place where there's only $1 million, and I say that kind of laughingly, only $1 million, one of the banks is saying this trust is not marketable for us anymore and we don't want to do it. With $1 million, they don't want to do it. And so now they just are not going to help him anymore. In fact, they went to court and they ex parte, which means behind everyone's back, they got a court order allowing them to resign. So my ward never had a say in that. I, as his guardian, never had a say in that. And they're just wiping their hands of this and saying, this is your problem. In fact, they started just mailing me his bills and they just said, this is your problem to deal with now. Now, I love my ward. I'm going to take care of him. I will do what I need to do to protect him. But I highlight that story because these people who provided for him to make sure that he had just an extraordinary standard of living, just a rich experience in life, is being abandoned by the bank that was chosen before they passed away. And it's terribly heartbreaking. Yes, the details are important. I'd love to share the bank's name, but I'm not going to. I'm not going to. Okay, concerning trustees, do you see situations where there is a co-trustee of a family member and a professional trustee both? Would that cover knowing the beneficiary and knowing the rules of a legal trust? I have actually never seen that, Annette. I'm sure that it's possible. What I expect is that the professional trustee is going to not want the interference, I guess is what I'm trying to say, the interference from the family member trustee. I just, I can't prove that, but I get the sense that like professional trust officers want people to just sort of stay out of their way and not have that interference. I'm sure you could find a small local bank that might be interested in that. I don't know that the bigger national banks would be. Maybe smaller credit unions or banks from a small town. I know Jones Bank. Jones Bank has been an extremely friendly bank to personal situations. In fact, they were serving as a power of attorney for the parent of one of my wards before they passed away, which is something I never see banks do. So Jones Bank was one that was extremely personable and professional in that regard. But other than Jones Bank, I've never really seen that done. My fear again is that the professional beneficiary wouldn't, really want to be involved with, I don't know, that supervision, or I'm not saying it's interference, but I think they could perceive that it is. What you might consider doing is having your family member be the trustee, but empowering them to hire people to help them carry out their role. This is something that is also done in really good estate planning. Normally, trusts will say, my trustee can hire professionals to be able to carry out their duties, which we typically think of as like attorneys, accountants, financial advisors. But you can expand that by saying, someone who can help me determine the best benefit, like what DD waiver or what Medicaid waiver should I have this special needs beneficiary on? Talking to someone who can consult on just the general care of like, how do we make this all work? Do we want to have a guardianship account? Do we want to have an enable account? You can hire people to help you do that. So you can expand your trustee's authority from kind of those traditional professional consultative roles to have really the sky's the limit ability to be able to hire people to advise them on how to do their job. So that might be something that I would consider doing before I tried to make a joint role. I would just expand the trustee's authority to be able to hire just a number of care, advisors to be able to make a wraparound comprehensive plan. How does a professional trustee maintain contact knowledge of a beneficiary's needs? Well, they have to know them. They have to know them. you know, I'm a trustee of some special needs trusts, and communication is key, but you also have to have the special talent of being able to read between the lines. I don't necessarily know how to teach that, which is why I think family members are the first people we should look at, because you know this person intimately in a way that a stranger or a banker wouldn't. But communication is definitely key, getting to know their likes and their preferences and the things that they don't like is really important. I think becoming their friend is probably the best way to do it. If I'm being honest, that's the way that I approach my guardianships. I don't come into someone's life and say, I'm your guardian now. You're going to do what I say. It's never like that. It's, hey, I'm going to church on Sunday. Do you want to come with me and we'll go out to lunch afterwards? And you get to know them and then you become friends. And then the relationship is not me telling you what to do. It's you coming to me as a trusted friend to help work through the things that are going on in your life. Like, I have this bill in the mail. I don't know what it's for. Can you look at it for me? Sure, let me look at it. Hey, I think this is a scam. I don't think you need to pay this. It's about developing rapport and trust and friendship, I think. Now, I think you could ask a lot of people this and you would get different answers. Not everybody is the same, but you communication at the beginning is just so important. Also, having a relationship with the family of the individual that you're serving for is really important too, because you might like be able to get family preferences and family information from some of these other people who maybe aren't serving as trustee, but can inform you about what childhood was like, what parents were like. You know, it's really kind of dependent on the circumstances of the case, but you've got to have open communication. You have to have a willingness to have a lot of communication. And I think, unfortunately, we see a lot of impatience with people in our special needs world. I'm sure you, as special needs parents, see that all the time. It's ubiquitous, it's everywhere. Just impatience with people who walk slower or talk slower or, have to repeat the things that they're saying. So communication and patience, I think, are the two important things. Does every financial institution charge an ongoing fee to administer the special needs trust? Yes, every financial institution is going to charge to administer a special needs trust. In fact, every professional trustee is going to charge to manage the trust. Probably the only people who won't do that are your family members. What wording do we tell aunts or grandparents to say in their wills? Oh, Stephanie, what a great question. You know what? After this, I will send out the slides, and in addition to that, I'm going to send you an example letter that I share with family members for this exact reason that explains, we know you love William and you may want to remember William in your estate plan. Please know that we are providing for William through a special needs trust, and it probably makes sense for William to not have more than one of those. So please talk to our lawyer about how you can remember William in your own estate plan. I have an exact example of this that I will send to you, but essentially what you're probably gonna want to instruct your family to do is to leave the inheritance to either you, and then you can provide for William in your own estate plan, or you can also leave it to William's special needs trust share in your plan. But I have a letter for this. I will send that to you so you can have that in your arsenal. Okay, we got about 15 minutes left, so let me get through some more slides. This is a good conversation. All right, I want to show you in real life how this might work out for William. So, mom and dad have a $1 million estate. Most of that is in their real estate and retirement. They do have some personal property. Personal property is things like their cars, checking, savings, and maybe a few collectibles. Then they've also got a life insurance policy. Now, mom and dad were talking to their attorney, and they said to their attorney, it's probably not realistic that William's going to use $300,000 or more in his lifetime. We think that it would be a better use of that money to give it to Sally Sue and Johnny because they've got families, they've got kids. It would be essentially making $200,000 unavailable to the rest of the family for William's entire lifetime. And while, yes, it might go to Sally Sue and Johnny's kids, it's just not being used in William's lifetime. And we want to make sure that Sally Sue and Johnny want to be able to use it now instead of later. So we look at this and we say, okay, we want to get William $100,000. Probably makes sense to allocate that to him in cash so that we don't necessarily have to sell real estate, for example. So in this particular situation, I might be advising these clients, hey, maybe William should be the beneficiary of your life insurance policy. Maybe you identify that William's trust share under your estate planning document is this life insurance policy. So my life insurance would say my beneficiary is the trust share created for William under the mom and dad revocable living trust. Or if we have $100,000 in a savings account, we can allocate that to William. But we want to look not only at the amount of money, but what the inventory of the estate is. We want to look at the type and character of the asset because it's very simple to say $100,000 to William, but we need to dig into that and say, okay, but 100,000 of what? Like if the only thing you have is a house and you want Sally Sue to get the house, but you want to give William $100,000, you can't make both things happen because you have to sell the house in order to provide for William. So again, it goes back to like not having this secretarial interaction with your lawyer. We want to peel back the layers and really figure out how the plan is going to work after you're gone. It's not enough to just say $100,000 to William. We want to say, okay, well, what's in your estate? Let's figure out how we're going to make this work so that we can allocate a specific $100,000 to William so that it doesn't compromise the rest of your planning. In this case, what you want to do with Sally Sue and with Johnny. Here's another example. Let's say they do want to leave William a third of the estate. So now each child is getting about $333,000. Part of this might be not actually dividing each asset equally. You might say, hey, you know what? I don't really want to have to manage an inherited IRA share for William. Now you can, it's not impossible, but it's not the easiest thing to do. So maybe Sally Sue and Johnny are talking to a lawyer and they're like, well, we're not going to take each specific asset of mom and dad's and divide it by 3. Maybe we're going to allocate all of the cash we can to William and leave the rest for us so that William's still getting 333,000, but not necessarily a third of each particular asset of mom and dad's estate. In this case, they might sell the real estate to prioritize William's cash instead of giving him an IRA share. Now, I'm not trying to villainize inherited IRAs. In fact, I was a little timid to even put this on the slide because then I thought someone would ask me about inherited IRAs, which could be a full day workshop. So I don't want to get into any of those higher level details, but just know that the point here really is it's not about just saying, this is who I want to have protected. This is what I want them to get. We really have to think about what that plan actually looks like when you're gone. The good news is there's a lot of ways to accomplish what you want. There's almost never only one way. There's probably a lot of ways for you to be able to prioritize your goals. You just need to partner with someone who's going to be able to help work through those discussions with you. Okay, is it correct that they can leave money to the individual that can be converted into the S&T later? I'm not exactly sure what you mean by that, but if the question is give cash to the individual first and then transfer it into an S&T, you're talking about a different thing. So it would never be that grandma and grandpa leave money to William and then William can put it in a third-party special needs trust. He would never be able to do that. That's why planning is so important because once you lose the third party characteristic of the money by actually giving it to William, you lose all the benefits of third party planning. If for some reason grandma and grandpa, aunt and uncle, for whatever reason, didn't follow Stephanie, your letter of instruction that I'm going to give you a copy of, and they give $100,000 to William, William can still put it in a special needs trust. But that was the different example I was talking to you about earlier, which is the $100,000 going into a first party trust. So William could do what you're talking about. He could take the cash inheritance, he could put it in a first party special needs trust. He would still maintain eligibility for Medicaid and SSI, but there's a big difference here. At the end of William's life, the state of Nebraska says, well, okay, you got this $100,000 and we still paid you Medicaid. We want whatever's left. We want the balance of that trust when you die. So it no longer goes to grandma and grandpa's other kids or grandchildren or a charity that they wanted. They lose all the ability to direct that. And the state of Nebraska says, okay, you can do this in a first party special needs trust, but if you don't spend that money, it's coming back to us. That's obviously not what grandma and grandpa, aunts and uncles, mom and dad really tend to want for their money. They want to keep it within their family. So it's a big mistake to give the inheritance directly to the beneficiary, even if the beneficiary later can remain eligible for their benefits. It's not the best planning strategy. Okay, I'm going to tell you a secret. I don't know if a lawyer has ever told you this before, but a common misconception is you can actually have a special needs trust in a will-based plan. So you can actually do that. You can have a testamentary trust that's created in a will that provides for a special needs or even underage beneficiary. So you can actually do both a will-based plan or a trust-based plan and still have the same things that we're talking about today. That's something that I don't know many lawyers explain to clients. So a special needs trust does not necessarily thrust you into only a trust plan. You can have a will-based plan, you can have a trust-based plan, you can engage in these protective strategies in either. But with a will-based plan, you're going to lose the other protective strategies that a trust provides. I've put some examples on the screen for you. So creditor protection is one, divorce protection, remarriage protection, or delayed distributions over time. Some people, if they have younger kids, they don't want their 19-year-old child to get $250,000. They want to be able to make sure that their child gets it on some certain time horizons. Like if you want them to go to college, maybe there's a distribution at 18 to pay for that. Maybe at 25, they're planning for a wedding. So there's a distribution to pay for that. And maybe you're talking about giving them the rest of their money at 35 or 45 after they've kind of grown out of their child decision-making phase. Sometimes people, are really concerned about that. Remarriage protection is another big one where, unfortunately in our society today, there's just a lot of divorce. And when that happens, or even a death, maybe that's a better example. There's a death. You are married for a long time, one of you passes away, you're never going to be able to replace that love, but loneliness is a big deal and you get remarried. The person who passed away wants to make sure that their money is not going to the new spouse. They want to make sure that their money is going to their kids. So trust-based planning provides remarriage protection if it's included. Creditor protection is important so that creditors can't, infiltrate trust assets to be paid. Divorce protection is another thing. Like if your child is going to be inheriting from you and they're currently going through a divorce, you can give your trustee the power to hold the distribution back so that it doesn't become part of the divorce proceeding. So these are not all of the protective strategies of a trust, but these are some of the main ones that are involved in trust planning that you'd be giving up if you put a special needs trust in a will-based plan. My point of this slide is to just be transparent with you so that you don't have to have a trust to do these protective strategies. Even if you have a will, you can still use the same strategies to protect a special needs beneficiary. Now, one thing that people often talk about in special needs planning is, well, what's the cost? And so I have, some, I guess, more pull the curtain back information for you, which is we actually don't see a huge difference between the two types of planning. A lot of people think that will-based planning is cheaper, more affordable than trust-based planning. We actually find that it evens out. It's just a question of where you want to allocate the cost. A will-based plan is absolutely more affordable for you up front. So it's something that you can easily obtain but it tends to be more costly for the people who are administering your will after you're gone. They have to hire a lawyer, they have to probate your will, they have to get letters of personal representative, they have to go through the court process of being able to transfer your assets and get authority to do that. And so there are more delays. It costs more because of the court process. And so it's where do you want to allocate that cost? Do you want it to be more affordable for you up front and less affordable for the people after you're gone? Whereas a trust-based plan is the exact opposite. It is less attractive up front because it costs more, but it tends to be more affordable for the people who are carrying out your instructions on the back end. They probably still want to work with a lawyer, but they don't have any of that court process that just has delays and expense related to it. They are immediately capable of carrying out your instructions. There's no delay. You don't have to file anything. And so for that reason, a lot of people do choose trust-based planning, even though it is not as affordable on the front end as will-based planning. So it's more really important to not talk about the overall cost for you, but what do you want your plan to do? You know, that's the biggest piece of it. What protections do you want your plan to have? And what do you foresee for the people who are going to be carrying out your instructions at the end of your life? That's kind of a better analysis in my view. Okay, we're coming to the end of our hour together. Let me see if I've got more questions. Once created, how often do you recommend a trust be reviewed? Well, actually, that's on this slide. So this is your next step slide. And we say at any time there's a major life event, a birth, a death, a divorce, an adoption, that is a really good time to revisit your estate plan to see if changes are needed. And for the month of August only, if you want to come into the office and meet with an attorney to review your estate plan or talk about an estate plan if you don't have one, we are waiving our initial consultation fee. So you can mention this workshop that you joined me live or that you listened to the replay on our podcast or that you watched the video on YouTube. You can meet with one of the attorneys here for free. That's $325 back into your pocket for nothing. To look at your estate plan, to see if changes need to be made, or to discuss an estate plan, or to talk about changing from a will-based plan to a trust-based plan. Often we see that too. Younger couples start with a will, and then as they have children and they age, maybe it's time to start looking at some of those protective strategies. Especially too, as your children grow up, you know, and they become adults, you don't necessarily need the things in your plan that you originally had, like guardians for them, for example. So a birth, a death, a divorce, or adoption are all big situations where we think you should revisit your estate plan, but it never hurts to have it looked at any time. Laws change, goals change, but these triggering events are typically what we suggest. So I will hang around for a few more minutes if anybody has any questions. So just remember, everyone's family is different, and there are so many options and tools to accomplish what you want. It just starts with a conversation and identifying your goals. So B Shoop is asking for address. I'm not sure. Are you asking for the office's physical address? I have Blazek Law Group's phone number and our client coordinator's email on screen. That would be the best way to set up an appointment with us. So our phone number is there. Reception at blazeklawgroup.com takes you directly to Devin, who is our client coordinator. She's fabulous. You will love talking to her. She can get you set up with an appointment. All right, I don't see any other questions. I've had a ton of fun with you this morning. Oh, one more question. Let's see. Is the job of a trustee as heavy as an executor? Ooh, Annette, what a good question. Mm, well, I think fundamentally they're doing the same thing regardless of the hat they're wearing because they're carrying out your instructions. But the trustee has a little more flexibility to do so because they don't have to go to court to get a judge to give them permission to do it. So a trustee can just, bam, carry out your instructions when you're gone. An executor has to hire an attorney, file a probate, get permission from the court to make decisions. So it's a little more laborious, certainly, because you have to wait for those steps to, you know, be accomplished. My son is dual eligible for Medicaid and Medicare. Is his resource limit 2,000 or 4,000? So if he's eligible for Medicare, I suspect that he's not receiving SSI. He's probably drawing from another parent's retirement. So if that's the case, there's not going to be an SSA resource limit. It'll be the Medicaid limit. So it'll be 4,000, Anne. You are welcome. You are welcome. Well, hey, if you have more questions following this workshop, just know our firm has a free legal clinic every Thursday at noon on Zoom. I will also send you the link for that because you can come back and ask any follow-up questions. We like to keep the conversation going. I think our clients will tell you that about us, that we're really accessible in terms of asking questions and getting you answers. We periodically do these workshops. In fact, this year we're rotating through 3 topics. So this month's topic was special needs estate planning. We're going to go into questions about guardianship next month, and then special needs powers of attorney the month following that. So we're doing a different workshop every single month. You can go to blazeklawgroup.com to register for every workshop the rest of the year if you wanted to. You are so welcome. Thank you for joining me this morning. Everybody, you have a great Saturday or whatever day you're listening to this or watching this. It was so good to talk to you this morning. I love talking about guardianship and special needs estate planning. Um, it was great to see you all. Have a great day, and I'm sure that we'll talk soon. All right, bye.